Today is Tuesday, May 6, 2014. The time is 10 a.m. It's my pleasure to call the order State of Tennessee Department of Commerce and Insurance Board of Funeral Directors and Embalmers. Ms. Johnson, would you please call the roll?
Robert Helms, Wayne Hinkle,
Here.
David Neal,
Here.
W.T. Patterson,
Here.
Jane Gray Sow,
Here.
Robert Starkey,
Here.
Anita Taylor.
Here.
You have 6 members present.
Thank you, Ms. Johnson. We have a quorum. We'll continue meeting as planned. We will now adopt the agenda for the meeting.
Motion to adopt agenda as presented.
Have a motion from Mr. Hinkle,
Second.
second from Ms. Taylor. Any discussion? All in favor?
Aye.
Continue on, okay. We will now review the minutes, which you'll find down at the bottom there from the March 11th, 2014 meeting and the April 8th meeting. Probably we need to do these one at a time, so we'll do the March 11th first.
Motion to approve the March 11th, 2014 minutes.
Second.
Have a motion from Mr. Hinkle and a second from Ms. Sow. Any discussion? All in favor?
Aye.
We'll now go to the April minutes.
Excuse me. Move approval.
Second.
Have a motion from Ms. Sow, second from Mr. Neal. Is there any discussion? All in favor?
Aye.
Minutes are approved. Our next part of Virginia, we Sunshine Law presentation with Damon Romano from the Regulatory Board's Legal Division.
I think Mr. Chick is going to substitute for him
Okay.
today and do the presentation.
All right, Mr. Cheek.
Specifically with regard to Tennessee case law, excuse me. We talk about the Sunshine Law in Tennessee, we're talking about really 2 acts, the Open Records Act and the Public Meetings Act. For the purposes of board members and commissioners, the Public Meetings Act is really the heart and soul of it, the gist of it. I'll touch very briefly on open records, just for the sake of getting new board members and commissioners up to speed, and so that everybody's on the same page. A lot of the boards and commissions have not heard formally about the Sunshine Law in 3 or 4 or 5 years. And so part of this presentation is to get everybody on the same page, clear away any cobwebs or misconceptions that may have accrued over the last couple of years, and again, as I said, to bring new members up to speed. The Open Records Act then includes pretty much everything. We can see here what's included all documents, papers, letters, maps, books, photographs, microfilms, electronic data processing, files, and output, films, sound recordings, and if that's not enough, other material, regardless of physical form or characteristics. So what is liable to be requested for a FOIA request, Freedom of Information Act request, or a Public Records Act request? It's pretty much going to be everything. As a day-to-day matter, it's the executive director and their staff that deals with that. There is also a state council of open records that deals with a lot of the FOIA requests at the higher end as well. That's pretty much it as far as a board member or commissioner needs to know. Excuse me. We'll move on then to the Public Meetings Act. We'll talk broadly about four things. What is the act? What is a meeting under the law? What's it do? What's it for? What's required of a board member or commissioner once we get into a meeting? We'll talk about what a meeting is not and try and put some bounds and fences around that. Once we know what a meeting is and what the act is, what's required for a board member or commissioner? And by the way, board members and commissioners, you'll hear me use that term, those terms interchangeably, and they'll be used interchangeably throughout the presentation as well. Notice, agenda, public presence, and minutes are broadly what's required. We'll see going through it that once we figure out what a meeting is, and once we figure out what notice requires, we've covered about 90 or 95% of the substantive content as far as the board members are concerned. Excuse me. The rest of it, the agenda, the public presence, the minutes, that is again going to be something that the executive director and staff takes care of on a day-to-day basis. All right, so we'll get into the code there. The General Assembly hereby declares it to be the policy of the state that the formation of public policy and decisions is public business and shall not be conducted in secret. Formation of public policy, folks, that's any time the board or commission adopts a new rule, amends an existing rule, repeals an old rule. Decisions includes any other decisions that the board or commission might take. Issuance of a license, revocation, discipline against a license, assessment of civil penalties, and so on. This is simply the free speech clause of the Tennessee State Constitution. The way to read that together with, in the context of this Open Records Act, is to understand that the limitations placed on the speech of board members and commissioners are voluntary, just as their service is voluntary. And the takeaway for board members is to understand that this is not meant to curtail your free speech as a citizen of the state, but merely to remind you that in your capacity as a board member or commissioner, pretty much everything you say is liable to be on the record and really ought to be on the record, and that the free speech clause cannot be invoked to prevent that from happening. The act is remedial in nature and should be construed very broadly. And we'll see that as we go forward, every single time without fail that the courts in Tennessee address this matter or that the legislature goes back and addresses it, it's always going to be in this very broad, very expansive language. They are trying to leave no loopholes at all. The previous section said that all the commission's policies and decisions are public business. This part of the code is telling you that all of the meetings are also public business. And again, that very broad language, all meetings of any governing body are open to the public at all times. That exception, by the way, here at the bottom is the very narrow executive sessions exception, which implicates board attorneys especially. Excuse me, and we'll talk about executive sessions in a little bit more detail as we go on. It applies to all regulatory boards and commissions. Governing body means the members of any public body which has 2 or more members with the authority to make decisions for or recommendations to a public body on policy or administration. Excuse me. Well, if a governing body is just part of a public body, aren't we just moving the problem back one step? The Tennessee Supreme Court here is telling us that the legislature intended by this language to include any, quote, commission, board, committee, agency, authority, or any other body by whatever other name, whose origin and authority may be traced to state, city, or county authority. Excuse me. The governing body of a public body, then, is there to tell us that the legislature means to include all the committees and subcommittees in addition to the full or plenary board or commission meetings. So the question came up earlier in the year from one of the commissioners, well, can we, as long as we do the plenary meeting on the record under the gavel, can we do our subcommittee meetings or our education committee meetings and such as that behind closed doors? No, we're picking up everything here. All right, what's not a meeting? Does not include any on-site inspection. Many of you have staff investigators that, as part of the program, will go and visit job sites or commercial locations to make sure that they are following the laws or regulations or rules of your particular board. Excuse me. We can see that there is no on-site inspection that rises to the level of a meeting. And obviously that would get unwieldy very quickly. Meeting is not a chance meeting of two or more members of a public body. So if you happen to bump into each other at the grocery store or the gas station, that's not a meeting if two or more members or commissioners run into each other. However, those chance meetings or informal assemblages cannot be used to decide or deliberate public business. We'll see these three Ds in here: decide, deliberate, and debate. Anytime one of those things is going on, it's got to be on the record, it's got to be under the gavel and properly noticed. This case that I referenced down here, I know the font is tiny. Aiken v. the town of Kingston Springs. Kingston Springs undertook to annex some unincorporated county land that surrounded it. And while they took the final up or down vote whether or not to annex on the record under the gavel, the decision about which parcels to annex, carving out the lines, was done in secret behind closed doors. Excuse me. And so somebody who was annexed and didn't want to be, of course, sued and said that, in fact, the town eventually won, but it went up to the State Court of Appeals before they did. They said, look, because the final vote was taken on the record under the gavel, there was a substantive violation, but it was cured. However, what I'd like to propose to the board members and commissioners is that, folks, if you get sued, you've already lost. The massive sinkhole in time of your staff, budget, the time of your attorney, your own time being summoned to Nashville, which is where all this is going to happen, to be deposed, to have to give testimony, all of that is a big chunk out of your lives, and so for safety's sake, ought to be avoided. What's not a meeting? The Tennessee AG released an opinion that said two or more members of a public body can share a meal together in which public business is conducted, but that discussion should not constitute deliberation. Folks, if you think that you can reckon pretty accurately what a judge is going to say some number of months or maybe even a year or two from now as to whether or not your discussion rose to the level of deliberation, you're smarter than I am, which frankly is not that hard, but you understand my point, that it's a very fine line. It's not a meeting. Again, from the AG's opinion, lunch breaks, restroom breaks, smoke breaks, recesses between morning and afternoon sessions. If you have a multi-day meeting, that adjournment at the end of the day and then overnight to the next morning, not a meeting. But again, then discussion of board or commission business is off limits during those times. Regular meetings and special meetings also count as meetings and are both subject to the Public Meetings Act. By the way, this special meetings clause will pick up emergency meetings as well. If your board or commission ever says, look, we've got some egregious bad actor and we simply cannot wait until the next regularly scheduled meeting to address it, we have to establish an emergency meeting and get this taken care of now. You'll notice that even those so-called emergency meetings are scheduled out 2 and 3 weeks ahead of time because, again, they're picked up by the Public Meetings Act and proper notice has to be given. All right. I mentioned before that there is one exception, and is that executive sessions exception. So let's get into that. 3 requirements for an executive session. When one or more board members or commissioners meet with their board attorney, that's usually going to be the program attorney, and the board or commission is under lawsuit or has been threatened with a suit, and the board members or commissioners ask their attorney questions related to that suit. That can be the plenary board, or it can be an individual member acting in his or her capacity as a board member. The board or commission may not deliberate about any specific matter before it or potentially before it in an executive session. So if somebody between a morning and afternoon session comes out into the hallway and says, Mr. Commissioner, Mr. Chairman, I really don't like the way y'all decided that policy or made that decision against my license. I'm going to sue you. That's the perfect opportunity then to get with your program attorney, your board counsel, seek his or her sound legal counsel behind closed doors. Excuse me. And you can ask the questions of your board counsel, get their advice on what you can do, what you should do, what the consequences of any given course of action might be. But once you get to the point where you say, well, based on the information the attorney has given us, I think we should do X and so. No, stop. That's where we need to back off, get back into the committee meeting room or hearing room, get back on the record, and get back under the gavel. Excuse me. And so that's where we are there. I cite another case down here, Lewis v. Cleveland Municipal Airport Authority. Lewis was putatively a case about the abuse of executive sessions, but the court ruled that there was a rezoning at issue at the end of the runway to extend the runway eventually. The court ruled that it was decided at a public meeting that was at the regularly scheduled time, and so it really wasn't an executive session at all. It was a regular meeting, and so there was no violation. There might have been an issue over inadequate notice in Lewis because notice of that meeting was not published in the paper. And the Municipal Airport Authority's original defense was, well, we didn't publish it because it was an executive session. And the court comes back and says, no, it was not an executive session, but you didn't violate. Also, there was no notice problem ultimately because that meeting was held at the regularly scheduled time and place where the airport authority always had their meetings, and so custom dictated that people knew or should have known that the meeting was going to be held at that time and place. How far does it go? We have a AG's opinion again. Here you had the Civil Service Commission of Maury County was doing sort of first-line interviews of persons. They would then go into a closed session, discuss those interviews, the persons that they had interviewed, and the people they liked would then go on to a vetted list. And the county sheriff's department would hire from that vetted list of people. Here we have the AG saying those discussions after the interviews are probably subject to the Public Meetings Act because of the profound impact that those hiring decisions would eventually have on the public. And you think, my gosh, job interviews? Yes, this is how far it goes, or is likely to go. And again, because of that profound impact that's going to be had on the public. Touch briefly on electronic communications. If a board member or commissioner emails the chair saying, hey, I found something, piece of news that's pertinent to what we do, the content of that communication that's off the record is kosher. It's perfectly legit. If you call the chair and you say, I'd like something included on the next agenda, X and so, because I discovered it in the news or on the internet or what have you, that content is perfectly fine. But if you say, here's a news article that has negative things to say about one of our licensees, and I think as a result of this, we need to seriously consider taking action against that licensee, stop. Now we're moving into the realm of debate, deliberation. That board member here would be offering his opinion, or the courts would consider that that board member is offering his opinion about how he might vote. And so that's something that would need to be on the record. We'll see as we go on that even though the content that I've hypothetically described to you is perfectly legitimate in its substance, there may still be a reason not to make those communications. If a board member in the meantime or commissioner emails the board attorney, that's perfectly fine. I have a question about the legal consequences of something the commission has done. And you'll see this a lot. One board member or commissioner will say, gosh, I got outvoted. And I just don't feel comfortable with the vote. So I'm going to contact the program attorney or the board attorney and seek that person's advice about this. That's fine. Excuse me. If, for example, this came up at a prior meeting, you had a commissioner who went out to speak to a trade group on behalf of the commission. Without having received the opprobrium of the commission, there was no vote saying, we vest in this person the authority to go speak on our behalf. And so that called down the wrath of the rest of the commission on this one member, and he said, well, am I in trouble? And he went to the board attorney to ask that question. And that's exactly the person that you ought to be going to in that kind of a circumstance. However, remember that as a board member or commissioner, the board counsel or board attorney is there to counsel you in your capacity as a member of the board, not in your personal capacity. So if you say, the board's done something that I'm not sure about, can I get your legal opinion? Fine. Or I've done something on behalf of the board and now I have questions as to whether or not that was appropriate, that's fine to approach your board counsel about. Not, I just got picked up for my 19th DUI in 14 days. You might need to seek other counsel. You will need to seek other counsel at that time. All right, electronic communications. This is a sticky wicket for a lot of our board members and commissioners, and so I want to spend a little bit of particular focus on it. If a board member, we talked before about the idea of the chance meeting, and that the chance meeting is not considered to be a meeting under the law if you run into each other in the grocery store or at the gas station. The court's going to say, if you email or telephone another member, that's not a chance meeting. It's never a chance meeting. Almost by definition, there was a deliberate act taken. One commissioner made a deliberate act to pick up the phone or to type out that email. And so there's nothing chance about that meeting. That was a deliberate communication, at least by one of those parties. And so they're not going to meet that chance meeting exception there. This is the cautionary part that I was talking about a few slides ago. Even if you don't discuss commission business with another commissioner or board member, folks, it gives a massive appearance of impropriety. It raises a huge red flag. If one board member calls another board member and says, gosh, I heard that y'all got caught up in that ice storm that we had here a couple of months ago. I know you live in that area. How are you doing? Are your folks okay? Is there anything we can do to help? Or, I saw your granddaughter in that church play a few weeks ago. Wasn't she cute? We all know that the content of those communications is innocent. But that's not what the public is going to see first, or possibly the news media. What they're going to see first is you've got one commissioner communicating with another commissioner off the record, under the radar, and it's going to look very bad. And so again, I'll say that for safety's sake, those kind of crosstalk communications between members ought to be avoided to the highest degree possible. And folks, bear in mind too, I'm not here to try to scare the daylights out of you or necessarily to put the fear of God into you or to tell you what you can and cannot do. but rather to let you know that there are some very clear consequences that will abound and accrue to you if you choose a certain course of action, if you choose to ignore this information. Electronic attendance. Many of you already know that board members or commissioners sometimes cannot attend a meeting in person. They may participate telephonically and we pipe their voice in over the PA, and that's fine. But at that point, all votes on any matter have to be roll call votes. There is no all in favor say aye, all opposed nay. Why? Because if there is one person or more than one person voting, but their shining faces are not physically present in the committee room or the boardroom, we're going to say the public has a right to know who's voting how. And so everything needs to be a roll call vote. Again, that's something that, as a matter of course, the executive director will take care of on a day-to-day basis. So if you find yourself in that situation, you may find your executive director calling out names. All right. What about quorum? If you can't get enough people in person to make a quorum, normally we would say, well, you can't hold your meeting. However, we have this mechanism that we call the statement of necessity. So if you have, for example, 9 people and 5 of them cannot be present in person, the chair or the acting chair who is present in person can say, all right, we understand that we have a rule that requires us to make a quorum of in-person, physically present persons. We also understand, however, that we have a public mandate to conduct this business in a timely manner. And so we're going to adopt the statement of necessity. It's a simple vocal statement adopted on the voice record that says these things. And therefore, since we can get to a quorum by including people telephonically, we're going to go ahead and do that. That's our necessity. Then it's for the record. And then anybody coming in after, any member of the public coming in after can say, okay, this is why they went forward with their meeting, even though they didn't have a quorum physically present. The act is to be construed most favorably to the public, is all-encompassing, applies to every meeting of a governing body, except where the statute on its face excludes its application. This, again, that very broad, very expansive, all-inclusive language, no loopholes here. This exception, this exclusion here, has to do with the public fisc. If you are a body that has the power to commit the state treasury to spending certain monies, forming contracts with the state, to the best of my knowledge, there is no board or commission within the Division of Regulatory Boards that has that authority, and so this exclusion does not apply. All right. Attendance of the public. Public has a right to attend and observe your meetings, but not necessarily the right to participate. A chairman or a board member or commission can vote and say, this is a matter of vital importance to our licensees, and therefore we want to give them an opportunity to speak on it. But you can place reasonable limits on it as a board or commission and say, we have an agenda, we have to get through our business today, we're going to limit public comment to, say, 30 minutes, and any given speaker can only speak for 60 seconds. Any of that is fine. As long as you treat everybody the same, you're okay. But you're not required to let anybody speak. Excuse me. Move to notice, then. There is a 3-pronged test for adequate public notice: contents, location, and timing. The contents of the notice have to reasonably describe the purpose of the meeting or the proposed action to be taken. Here's our key language here, reasonably describe. It came up at a meeting, actually a couple of meetings. There were several board members who were convinced that the agenda of the meeting, once published, was carved in stone, and that they were bound to it with heavy chains, and that it could not be altered one iota. It's not true. It has to reasonably describe. The idea is to give the public some understanding of what's going to happen at that meeting today, so that if you have a member of the public or a licensee that is particularly interested in a given issue or subject or case that's coming before the board, they can read the agenda and say, okay, if I show up at this meeting sometime today, this thing that I care about will be discussed. That's all it's there for. It's not there to prevent the board from doing business. And by the way, we can see that at the bottom of every agenda, there is a line item that says new business. Well, nobody knows what that is going in. And so again, we see that clue that it's a suggestion or a recommendation that ought to be followed as closely as reasonably possible, but it's not carved in stone. Timing of the notice. If you give the most accurate notice possible 20 minutes before the scheduled meeting, that's not going to do anybody any good. Your board is going to find itself in violation of the Sunshine Law for providing inadequate public notice. Again, as a matter of course, the timing of the notice is something that the staff, the executive director, takes care of on a day-to-day basis. Most of you, if you go to your board or commission website, you will find all of your meeting times for the next year already posted up there. And so we're well ahead of that requirement. If you give the best notice in the world a year in advance, but the only place you post it is in the basement next to the boiler room, that's not going to do anybody any good. And so we say that the notice has to be posted in a location where a member of the community could become aware of it. 3 usual methods: internet, newspaper, and bill posting, which is stapling flyers up everywhere. We use the internet. That has the broadest or widest possible circulation. And the meetings of most of our boards and commissions are listed, the times and places are listed on the board's website, also on the Department of Commerce and Insurance website as well. AG again says our usual practice is to publish notice of meetings and regulatory boards and commissions on the commission's website and the department's website. We don't use newspapers anymore. There used to be that phrase, newspaper of wide publication or newspaper of general circulation. Now we have that thing that gives the widest or broadest possible circulation, again, the internet. The only place you'll really see the newspaper of general publication or wide circulation being used anymore is at the municipal level. County sales of land or seizures of property, things of that nature. The idea there is to protect citizens of that county from having their property seized and then the county coming back and saying, well, you know, we published it in the Costco flyer and that's written on newspaper. No. So we've got to have that wide circulation in that case. Each factor of that public notice test is not dispositive. It isn't all the facts and circumstances. You've got to do all three. Finally, then, we talked, or you saw earlier, about the legal effect of violating the Sunshine Law. It is simply nullity. We're going to pretend as though it never happened. We will rewind the clock to the time at which the bad decision or the violation of the Sunshine Law occurred and wipe out everything, wipe out that and anything that necessarily flowed down from that. There's one case I'd like to tell you about with regard to nullity. In particular, it involved the Shelby County Commission. There was a long-serving member of the Shelby County Commission that passed away in office, and so the appointment to fulfill the remainder of his 4-year term was by vote of the remainder of the commission. And so they come into session and they note the death of this man. They send their condolences to his family and so on, and then they adjourn. This gentleman represented a strongly minority district, and it was within the county, and it was felt that that had to happen again. Excuse me. And so 3 other members of the Shelby County Commission took it upon themselves to begin communicating with one another off the record with the best of intentions to make sure that the right man for the job or right person for the job got appointed. And so in a series of phone calls and emails and letters betwixt and between themselves, these 3 remaining members of the Shelby County Commission developed a short list of candidates. And then they eventually narrowed it down to one person. And one of these 3 called that guy and said, "We think we'd like you to serve on the Shelby County Commission. If we appointed you, would you serve?" And he said, "I'd be honored." And so you have the next meeting of the plenary committee, the plenary council of the Shelby County Commission, and they all get there and they say, "We've got this vacant chair. Are there any nominations?" One name was put up for nomination. Great. Is there any debate? There was no debate. All in favor say aye. It was a unanimous vote. And the man was sworn in and took his seat. And of course, to the members of the public, something didn't smell right about that. One nominee, no public debate, come on. And so they sued. And sure enough, the court came back and said, and again, this went up to at least the Tennessee Court of Appeals. So they did that whole litigatory dance a couple of times, at least. And the court came back and said, his appointment was void. That is the textbook definition of a violation of the Public Meetings Act. And what that meant was that, and this is the real fallout of it, the court then says any decision where he was the deciding vote, void. Any committee he chaired or subcommittee he chaired, all those decisions had to be re-scrutinized for validity. And so we see this legal effect is nullity, but it can sometimes not just be that one decision, that one violative act of the Sunshine Law. It flows downhill. And so with the best of intentions, they set the work of the county, and you know, folks, Shelby County is not a small place. And the work of the county ground to a halt for several months and then was rewound, and several months of work that they had done was basically wiped away, and they had to go back to the beginning. There is a case that is not referencing the Public Meetings Act, but references the Open Records Act. Rebecca Little versus the city of Chattanooga came out on St. Valentine's Day, February 14th, 2014, this year, just a couple of months ago. So in legal terms, it's hot off the presses. Excuse me. And it is a reversal of the typical American rule that win, lose, or draw, everybody pays their own legal costs. Here, the court decided that the city of Chattanooga needed to go ahead and pay the $70-some-odd thousand of attorney's costs and legal expenses that the member of the public had incurred in suing. It was the but-for finding that but for the city's bad act, she would never have had to incur those costs in the first place. And that got bounced up and down from trial court to appellate court 2 or 3 times. By the time you get down to the final decision saying the city has to pay her legal costs, they have to pay all of her legal costs, it was the 5th time on appeal for that case. And so there can be substantial costs potentially associated now that we have that precedent with a violation of the Sunshine Law. Folks, that concludes, for the most part, the substantive portion of the thing. Just in a nutshell, then, the Public Meetings Act is designed to make sure that all regulatory board and commission business is conducted in a way that's accessible to the public. It applies to each individual board member and commissioner, as well as to the whole board or commission. All gatherings of more than one member are meetings and are covered by the Act. So if there is more than one person in a room discussing board business, it is almost certainly a meeting. If you are standing at home alone, staring into a mirror, discussing board business, it's probably not a meeting, although you might want to seek attention of another kind. The only exception then is our executive session. We will pick up our committee and subcommittee meetings. The only exception is that executive session, which is your opportunity to ask your board counsel any questions related to a suit or potential suit. But again, you can't use that as an opportunity to deliberate, debate, or decide. And for every meeting, you have to give adequate public notice in terms of content, location, and time. If you violate the law, the violative act is void. Costs of litigation could potentially be assessed against you, based on that case that I just mentioned. If there is any doubt in your mind as to whether or not something that you're doing as a board member or commissioner could potentially violate the law, it probably is a violation of the law. As I said throughout, the law is designed to be all-encompassing and to leave no loopholes. Some members that I've presented this to before have said, well, that's going to destroy our efficiency. That seriously handicaps our ability to conduct our business in a timely fashion. And sometimes that's the case. And the legislature has said, and the court has said that the legislature has said time and again, being totally above board about all of this is more important than strict time efficiency. Why? Because these members of boards and commissions haven't been elected. If the people of the state of Tennessee elect a governor and they don't like his decisions, they can vote that person out of office. But board members and commissioners have not been elected. They've been appointed. And these sunshine laws then are designed at heart to provide the public with a neck around which they can put their hands and shake vigorously if they need to. It is a tool of accountability. Excuse me. And so, if you think that anybody is going to object to what you say behind closed doors, and that's why you want to say it behind closed doors, it probably should not be said behind closed doors. That's the end of the presentation, folks.
Good morning. My name is Sam Payne. I slipped in. Adrian, I appreciate you running the audio-visual. I'll make this brief. I think I've been before the board before. I may not have said much, but my title is Director of Legal Services and Deputy General Counsel. So basically what that means is I oversee the various attorneys, whether it be Ms. Richardson or Adrian Chick, that work with the various boards and commissions. I don't actually do the day-to-day work, but I'm here to oversee and help those people do their work. I know Adrian's one of our litigating attorneys, or you might view him as a prosecuting attorney when push comes to shove and we have formal charges filed. He's got some matters to present, I think, today. As far as the PowerPoint there, that was Damon Romano. I don't know whether anybody mentioned it, but he's about to graduate from Belmont Law School, so he is not yet a lawyer, but he did a very good job with that presentation, and we eventually decided to put it on videotape for situations like this. I'm here, other than the fact, obviously, I want to encourage you to consult with Ms. Richardson at any time anything comes up. You know, a lot of these things are hard to really deal with in the abstract. They come up in real situations. So I would encourage you to work with her going forward on any questions that come out of this. But having said that, and particularly since Damon is actually not a lawyer yet, I needed to be here and answer any questions. We've given this presentation 10 or 12 times now, so we probably are out ahead of I think a lot of the typical questions, but again, I'm here to help answer any other questions based on that, or we can just move on to the next thing at your pleasure.
Explain to me the section where if you didn't have a quorum, you could, well, I'm not remembering the exact terminology, but did that mean that you might be able to call a board member that was absent and have a conference with them tied together, or would that?
Right. What you're saying is correct. I guess there's 2 points to it, all in the way of making sure that our meetings, however they happen, are legitimate and don't violate the law, including not violating the Sunshine Law. You have to have a quorum for any meeting, just as a matter of procedure. The quorum can be accomplished with some of the people not being physically present, rather being by telephone, but that's got to be, and I'm sure y'all have done this, seems like maybe we did it for those. Anyway, the person can be participating by telephone, that produces two possible scenarios. The first one is and again, this isn't necessarily the Sunshine Law, this is just proper procedure and Robert's Rules of Order, I guess. If someone is on the telephone voting, I believe whether that person was necessary for a quorum or not, you can't do the roll call vote thing. Excuse me, you have to do the roll call. You can't just do the voice acknowledgement. So that's an important point. It's not literally a Sunshine Law point. The other thing about it is the statement of necessity. You heard that term in there. If the people participating by telephone is literally necessary mathematically to get you to the quorum, then you've got to do the statement of necessity. And so if that's not done right and in advance, then the meeting isn't open, and that would get you in trouble with the Sunshine Law. That was kind of long-winded, but I
There's a
think.
term I was searching for.
Right, and again, we did a statement of necessity, as I recall it, just right around the new year to get that done, and that was a little bit, speaking about inefficient, that probably was a little inefficient, but that's what we had to do to get it done. Any other questions? I'm not necessarily offended if there aren't any. That means we did a pretty good job on it, hopefully. But again, things come up, and that's where Ms. Richardson comes in. Okay, thank you. Next on the agenda.
We'll now recognize Mr. Adrian Chick, Assistant General Counsel. Presentation of an agreed final order.
Good morning, Board. I think I'll sit here as opposed to up there because I don't believe there's a microphone up there. But there should be on your iPads an agreed final order. Last meeting, I mentioned to the Board that there had been a case before the Board against an establishment, but that establishment was closed, so that case was closed and charges were refiled against the managing funeral director. That's the case that you have in front of you now.
Mr. Chairman, I ask to be recused during the consideration of this final order.
So noted.
So rather than read it, I'll just give the board members a chance to look through it, and if you have any questions, I'll be glad to answer those.
Agreed to pay the 1,500 plus the 200 additional cost, is that correct?
Yes, sir, that's correct.
And the 200 additional cost is for the time matter in this situation?
That's the filing fee that we are assessed when we file with the Administrative Procedures Division. And I'll also point out that the civil penalty that's included in here, that's significantly larger than what was previously offered to them. So it's there's some provision in there to make, besides the filing fee, there's provisions to make up for additional time that legal counsel had to spend on it.
And in this, how long do they have to pay this?
This has already been paid.
So this is already all
Yes, sir.
paid.
Motion to accept the agreement for final order.
Second.
Have a motion from Mr. Hinkle, a second from Mr. Neal. Any further discussion? All in favor?
Aye.
Any opposed? Motion carries.
Thank you, Board. Mr. President, if I may, I'd present this for your signature.
Six, didn't it?
Letting the sunshine in. Look over yonder, 3 stories down, the window cleaner hanging outside that building. Oh, man.
I'm not going to.
All right, thank you, Mr. Cheek. We'll now continue on with the legal report from our Assistant General Counsel, Ellery Richardson.
So the first one is number 1, case number 2014006021. Complainant made arrangements with the respondent establishment for her father a week before he passed away. Upon death, respondent told complainant that they would not use the deceased's VA insurance. He told her that that insurance takes anywhere from 6 to 8 months to pay and it will be on a card. Because respondent would not take the VA insurance, she had to change the arrangements to a lower price and borrow money from relatives. After the burial, she started calling respondent about when the death certificate would come in, and respondent told her that it would take 3 to 6 weeks. After that time period had passed and there was still no certificate, she called the county health department and the hospital, and they both told her there was no record. When she called the funeral home and told them this, they said that the director would call her back, but he never did. She called the county health department again, and they told her that they have called the funeral home 3 times asking for paperwork. In response, the respondent discusses the arrangements. When complainant came in to select arrangements for her father, she chose a pricey package and told him that the VA would pay for it. Respondent explained to her that the VA would reimburse her through a card they will send her, and it might take a while for her to receive that reimbursement. Therefore, she chose a lower price service. And in regards to the death certificate, the respondent stated that the certificate was prepared and mailed the same week. When respondent called the hospital to check on the certificate, they realized that they had used the wrong address. Because of the delay, they reached out to the health department so they would be aware of the situation. Respondent states that they kept the complainant informed throughout this process. And then a member of the family came on April 1st to pick up the certificate when it finally arrived. So from the date of death, January 15th, it took until April 1st to receive the death certificate. And there's no prior complaints, so my recommendation would be to close with a letter of warning.
Motion to accept council's recommendation.
Have a motion.
Excuse me. The timeline, the date of death was January the 15th. The date the death certificate was filed was March the 27th.
Respondent states that's because of the confusion with the address that it took.
In other words, March 27th is when it finally got to the health department, I take it,
Right.
because that's the
That's
date
correct.
it was filed, yeah. I have a motion from Mr. Hinkle and a second from Ms. Taylor. Any further discussion?
Real lack of efficiency here on the part of somebody. 2 months is just. Something they're supposed to.
It says the death certificate was prepared and mailed the same week of the funeral. Of course, in my own situation, from time to time, we run into this at hospitals, especially with doctors being assigned to hospitals through a stat care, and then the hospital says they don't have it, then you have to resend it. They can't find it. So this is something ongoing and very bad, but so I can see where, on a personal issue, where things like this can happen. And if it's stated that, it was sent that week, and maybe, and when they followed up on it, they found out, so.
Used the wrong address.
We run into more where I went one time with the 5th death certificate to the doctor's office, and when the nurse opened it up, all the other 4 were in the file, but had never been signed. I said, well, there's the 4 you said you didn't get. So, well, I don't know how those got there. This was a 3-month situation too, so I can see where things like this happen. We have a motion, a second, all in favor?
Aye.
Number 2, it's case number 2011002621. This funeral home is no longer operated by the same management the complaint was filed against. Therefore, I recommend that the complaint against the establishment be closed.
Motion to accept.
Second.
Have a motion from Ms. Taylor, a second from Mr. Hinkle. Any further discussion? All in favor?
Aye.
Motion carries.
This last one is case number 2013-024421. This complaint is a consumer complaint, and the current consent order is for a failure to respond charge with a civil penalty for $250. When this complaint was presented in March. And then the complainant also filed a complaint with the Division of Consumer Affairs. And in a letter, respondent has asked that the board reconsider the civil penalty based on their misunderstanding that responding to Consumer Affairs would fulfill their obligations with both complaints. In this situation, the respondent had been communicating with Consumer Affairs, but they had mistakenly overlooked that they had to respond to our office as well. So I wanted to present this to you because the only charge is for the failure to respond. So I wanted you to consider that. But my recommendation would be to keep the civil penalty because our staff didn't receive it, so it would be difficult for us to review a response that we never received. Yes, sir. The complainant filed a complaint with our staff and with Consumer Affairs.
Failed to communicate with y'all, but they did with the Division of Consumers.
Correct.
Any explanation why they didn't correspond with y'all?
It was just a mistake on their part. They thought that responding to Consumer Affairs would be sufficient for both. It was just an overlooked mistake.
Consumer actually made a mistake in making an assumption.
The respondent.
Respondent, okay.
And do you communicate with the Division of Consumer Affairs?
We do not.
Okay.
I recommended we keep the civil penalty because there's no way for us to know ongoing whether they're communicating with Consumer Affairs or not.
I move to accept the recommendation.
Second.
Have a motion from Ms. Sal and a second from Mr. Patterson. Any further discussion? All in favor?
Aye.
Motion carries.
That is it for the legal report.
Okay, thank you, Ms. Richardson. We'll next go on to administrative matters. Mr. Robert Gribble, Executive Director.
Thank you, Mr. President. First thing I have to present to you is some financial information regarding the board. It's on your iPad there under the financial information. And what I have there is a document that we received on April the 24th from the Assistant Commissioner's Office. And that will show you year-to-date revenues for the board of $342,925.20. Of course, that leaves April, May, and June for revenue to come in. And as you know, there are many licensees whose license expire June the 30th. I think there are 1,550 something individuals and 200 and something establishments that have an expiration date of June the 30th. So anticipate that there'll be a significant amount of money collected the remaining 3 months of the fiscal year. Our total projected expenditures for the year is $542,500, and pursuant to Tennessee Code Annotated 4-3-1011, all regulatory boards are required to be self-supporting over a 2-year period. As you know, we have an up year and a down year, and every other year we do usually have a small deficit, but we have a reserve balance. So we're, for many years now, have been self-supporting when you look at it in a 2-year cycle. And our program is on track to maintain our self-sufficiency for this year, and as of June the 30th, 2013, we had a closing reserve balance of $714,380. So we just wanted to present that to you to make you aware that basically we're on track to be self-supporting, and so that you would know how much had been collected for July 1, 2013 through March of 2014, and what our total projected expenditures are. Does anyone have a question about that?
They come in occasionally and cut that back a little bit on us.
As far as the reserve balance, the history has been that, yes, at some point, reserve balances they're subject to the will of the legislature. So under this administration, there has not been any rating of the regulatory board's reserve balance. But that is a possibility. It could happen, and we do not want to build up a huge surplus, and that was the reason that the board did the rule to reduce the fees. Of course, that's still not in full effect yet, but it should be hopefully within the next few months. So again, there's no reason to build up a huge. I was always taught that you need a reserve balance of at least 1 year's operating expenses. So if you had some kind of catastrophe or something, so I mentioned that their expected expenditures for the board is $542,500. So as of June the 30th of last year, we had a little bit more than that, but not a significantly amount more than what a year's operating expenses would be. Should a reserve balance continue to increase, then we may want to look at reducing fees again at some point. This is the licensee's money that pays the operating expense of the board. There's no tax money. You know, each board has to be self-sufficient.
I think a lot of bar and funeral directors out there would love to have cut a little.
You know, at the end of the fiscal year, and we see where our balances are, and probably need a little bit of time to see how this first fee reduction is going to work and how that's going to, because we know that it's going to take away some from that reserve balance. So probably in another year and a half or 2 years, probably need to look at it and see if looks like there's a possibility of reducing fees again.
I think you're doing the right thing by getting it, cutting the
We watch expenditures closely, or try to be effective and efficient in those things. Not only do we watch them, but people up the chain watch what's done as well. So it's wasteful in anything, and to do things as efficiently, so do it effectively, do it as efficiently as possible. Any other questions about that? The next document you have before you is a report of licenses that were administratively approved by the executive director pursuant to the board's authority for the period of April 8, 2014 through May the 5th, 2014. Document is a closed establishment report. We have one establishment that's reported closing since the last board meeting. Hooper and Holston and Horner Funeral Home and Cremation Services located at 124 First Avenue in Allgood. If you're familiar with them, they did have 4 locations. They had 3 operate under the Hooper and Holston name in the Cookville, Baxter, and Allgood area, and then 1 operates under the Horner name in Monterey. So what they're doing, they're closing one location and putting that into building into other use. Disciplinary action report. This is a report of consent orders administratively accepted and approved by the executive director pursuant to board's authority for the period of April 1, 2014 through April 30th, 2014. And you can report presented in a little bit different way this month. One is because Ms. Mosby was not able to be here yesterday to get the documentation together as she normally does in the format that she has it. So Ms. Johnson assisted us, and we've come up with a different format, but we have the numbers to report to you. Funeral director and embalmer, there are 12 complaints open. Establishments, there are 46 complaints open, which makes a total number of complaints of 58. President, that concludes my report unless someone has questions.
Any other questions for Mr. Gribble?
I have one on the individuals who were granted their license. I'm not sure if this has been addressed, but I know when I received my license, we had the licensees come before the board so that at least they could see them and meet them. Is that possible at some point in the future? Those that were granted their license?
Probably about 8 years ago, the decision was made by the board. Instead of asking let me get back up and let's go back one step before that, Ms. Taylor. If you recall, at one time, not only the potential licensee came before the board, but also their supervisor, who their sponsor was during the time. And then because of what effect that had on firms and taking a funeral director and or embalmer out of the firm for that day, and also a potential licensee from the same firm, then the decision was made to just ask the licensee to come before the board. And so each month at the board meeting, all the applications for funeral directors and or embalmers would come before the board, as well as all applications for establishments. Well, the expense of that and the time being away, because some firms it was my understanding, some firms were requiring those people to take some type of leave in order to be away from the firm, even though they were coming to get a license where they would go back and practice in the firm. It was still their personal time that they thought they should use in order to do that. And then we had people that were having to come and spend the night. So because of lodging and travel expenses and things like that, probably about 8 years ago, the board made the decision to grant the director the authority to approve regular applications. Now, if there's anything at all that's out of the ordinary or it's not considered a regular application, and I consult with Assistant General Counsel if I have any question at all about whether it's a regular application or not, then I go to the attorney and say, is this one that we should bring before the board? And if we err, we always err on the side of bringing them before the board, and we do not, in other words, we're conservative about it. We take to heart the responsibility that you've given to, for me to review those and approve them, so we don't want to abuse that in any way. So if we have any question at all, we do schedule the applicant to come before the board. But that's the reason that all the applicants no longer come before the board. It's basically the cost of travel expense and the time away from the funeral home. That we also had funeral homes complaining still, if they were busy, this put us in a bind because you had that person to come before the board, and then they were requiring that individual to take leave lots of times. It's certainly up to the board as to whatever you want to do, but I also understand that that's consistent with what other boards, the way the board's doing it now is consistent with what other boards are doing as well.
Okay, next point on the agenda is approval of license applications.
President, can we get a motion to approve that report?
Oh,
Moved. Second.
have a motion from Mr. Neal, second from Mr. Hinkle. Any further discussion? All in favor?
Aye.
Motion carries. Moving on, the next will be approval of license applications, individuals and establishments. So I think the individuals,
There are no individuals. The next one to approve is an establishment license for Dusty Rose Cremations and Memorial Services LLC. If Mr. Hanson, if you will, please come up to the microphone here. And this proposed applicant is located. The establishment's located 5100 Poplar Avenue, Suite 2729 in Memphis, Tennessee. It is a LLC that's owned by Dusty Rose Cremations and Memorial Services LLC in Germantown, Tennessee. And Mr. P. Michael Hanson is the proposed manager and also involved in he is a single member of this LLC. So he's here today and to answer whatever questions you have. And also Mr. Roy Bozeman, who did the inspection at this facility and the next facility that's on the agenda, is here as well to answer whatever questions you might have. There are some photos that we have too that are in color. We attempted to put those on your iPad and we were not successful. So we're going to pass those to you to look at. Photos I'm passing will apply to the first establishment application. There are two, on your iPad, there are two different applications.
first one we're looking at is the Dusty Rose Cremation and Memorial Services LLC.
So you're applying for two
Yes, sir.
different locations?
Yes, sir.
First one's at 5100 Poplar Avenue.
Correct.
What floor are you on?
The 27th,
27th floor, okay.
closest funeral home to heaven.
Yeah, I would think so.
Cremations won't actually take place at this facility then.
No, sir, not at all.
Said funeral home.
Yes, ma'am. I use
It's
that
not a
term.
funeral home, is it?
It's a funeral establishment. If I may, I might, it will perhaps clear up a little bit of confusion. I've been working on this process for 4 or 5 years. The difficulty in Memphis and Shelby County comes down to the zoning requirements. They are so restrictive that in my personal situation, without having abundant resources, you can go into perhaps an upscale shopping area, or you can go into the industrial areas, one or the other, with very few places in between that are ready to move in for a funeral establishment. Now, obviously, I cannot take my bodies to the upscale high-rise Clark Tower building on Poplar Avenue. Likewise, I didn't feel comfortable bringing my families to meet where the bodies are going to be taken down in an industrial area near the airport. So I'll be meeting with the families in one place, taking their loved ones to another place to prepare them. And then services will take place at a church, which I have also included documentation on.
Was there not a photograph of where you plan to take the bodies?
It's on the other, it should
The other application.
is the other application. See, I had, by law, I had to have 2 establishment licenses and locations. Although I really didn't want it, I'm one company. I would rather have just had my prep room over here and my meeting space here, but by law, I had to have 2 separate establishment licenses, and that's why I've done this.
Financial reasons, you're having an office in this building right here?
Yes, sir, that's where I'll be taking families to meet with them.
Building. You see,
Also, board members,
that don't make sense to me.
there's a letter from Millington Funeral Home Incorporated in Millington from Miss Eva Smith, or Eva Smith, I'm not sure how she pronounces her first name, where actually they're going to be providing the embalming services to this establishment if it's licensed, and also to the other establishment. So, call to your attention that letter that's in your packet of information there on the iPad.
And the other thing, I see a letter here from the Whitten Baptist Church.
Yes, ma'am.
So that's where all of the services will be held.
Correct.
Instead of if the family opted for a chapel service.
For us to handle that, if they did not have a church affiliation, I have an arrangement with that Whitten Memorial Baptist Church. Of course, if the family has an affiliation, we'll be happy to go there.
And what you're going to be conducting it on Poplar Street then?
The arrangement.
You've got but you've got a letter where you're going to use a church. You've got a letter where you're going to use the embalming service. What are you going to be doing at 5100 Poplar?
100 Poplars, where I'm going to be making the arrangements with the families. I'm going to be drawing up the contracts, making the arrangements, conducting, doing the obituaries, selling some urns, that sort of thing.
Not going to be selling. You're going to sell urns there. You're going to have urns on display.
I will.
Okay. You're going to have caskets there. You're going to have.
I'm not going to offer any burial services.
Oh, just solely cremation.
Solely cremations.
Okay.
Totally cremation.
Yes, sir.
So what?
You're using a funeral home for embalming.
Well, ma'am, the second application that you see there is for Dusty Rose Mortuary, which eventually will be my prep room facility. Right now, the estimates that I've gotten, which is a very large facility, as you'll see, it's about 2,000 square feet, about a quarter of which we're going to have eventually turned into a prep room, an embalming facility with all the air conditioning, everything that's required. But the 2 estimates that I've got on that on the front end are for over $40,000. I can't do that right on the front end. So, and for the first year or foreseeable future Eva Smith at Millington Funeral Home. We'll be picking up our bodies, taking them to Miss Smith at Millington Funeral Home, then picking them up from there, bringing them back to Dusty Rose Mortuary, where we'll be casketing them, dressing them, getting them ready, and then taking them to the church for their services. But I wanted to go ahead and get that facility licensed as a funeral establishment, mortuary, so when the time's right and I do have the money, I can go ahead and finish out the prep run.
I thought you just said you was gonna do all cremations.
Yes, sir. My business-wise, I want to do full-service cremations. That's my marketing angle. All full-service cremations. I put direct cremations on the price list, but I don't particularly want to sell them. I've even priced them a little higher than some of the low-end direct cremations in our market. So I'm focusing 100% on selling the concept of full-service cremations.
I think we have to look at this at two different, we are looking at it as two different items.
Yes, yes.
Mr. Bozeman, have you inspected and found, I think all your paperwork's here.
What's your question?
You've inspected the
Yes, sir.
office building and
Both locations.
both locations, okay. The,
What's the signage, excuse me,
go ahead.
what's the signage issue? What kind of signage issue would he have at 5100 Poplar Avenue? This looks like a large, high-rise office complex to me.
That's basically what it is. Signage, I don't know what, there was no signage there. Of course, they can't put up any until they're licensed as an establishment, so.
Grants and I had a discussion about that, and I think once, if the board approves its license, or the establishment license, then there's a directory downstairs or something?
There is a directory in the lobby, electronic directory, plus there is a space, and the signage has been ordered for the door of my office. It just has not been put up yet.
What's your background?
My background, ma'am? Well, it's actually, before I got into this business, I had 20 years in the advertising business. That took...
Big and whistle.
Yes, ma'am. That was one of my clients back in that. Some fortunes turned on me, so at about 40 years old, I was forced to start life over and decided to go back to school and get into this business. Always having had the...
Where did you go to school?
Northwest Mississippi.
Beg pardon?
Northwest Mississippi for funeral school. I also have a degree
Funeral school?
for mortuary school. Northwest Mississippi Community College in Senatobia, Mississippi.
Hard to remember?
That's where I went to mortuary school. I also have a degree in journalism from Duquesne University in Pittsburgh.
Your background, working experience in funeral service?
I started out with the roller companies of Arkansas, worked there through my internship, then spent 4 years at Munford Funeral Home in Munford and Millington, Tennessee, then a year at Forest Hill, then Forest Hill in Memphis, then 2 years at Northridge Woodhaven Funeral Home in Millington, and most recently I was the prep room manager for all of the Forest Hill funeral homes in Memphis, responsible for 800 cases a year, embalming-wise, body preparation.
So when you get a call, you're saying that Dusty Rose Cremation Services will be in the high-rise building?
Yes, ma'am. That essentially is my public face.
Okay.
Dusty Rose Cremation, that's what's going to be advertised, Dusty Rose Cremations and Memorial Services.
Okay, so then the Dusty Rose Mortuary,
Nobody's going to go there. Nobody's really going to, nobody but me and the deceased and my partner, the removal gentlemen are even going to be going to that place.
Okay, so when you get a call and you find out that the individual wants a casketed service, they still will come to Dusty Rose Cremation
If they
to make arrangements?
if we will make sure that they're very aware that we offer nothing but cremations, and that's going to be certainly that's what I'm pushing in my advertising. So if anybody's misconstrued that they're going to come to me for a full traditional funeral, I will take care of that on the front end and let them know that they will have to go elsewhere. But yes, their loved one will be picked up, and I'll set up an arrangement for them to come the next day or whenever to 5100 Poplar Avenue to make the arrangements.
I guess I'm just kind of missing something.
Is, if a family wants to view the body, do they view it at the funeral home in, is it Millington, or whoever's going to do your embalming for you?
If the family insists on doing that without, again, my marketing approach, my advertising is going to focus on the idea of embalmed bodies and rental caskets for full service cremations. So they're going to see their loved one at the visitation in the wooden cremation casket. On those rare occasions when someone just, like I said, I'm not going to push direct cremations, but let's say I get one and they insist on seeing the body, then I'll have to meet them down at the mortuary down at the other location. But I'm pricing that. I don't want to do direct cremations, so I don't think that's going to be an issue very often. So people will see their loved one when they're dressed, casketed, and at the church for their visitation.
The ones at home don't want to do it either, but they're doing it.
Okay, what about the individuals who want a full service and a burial, and they just happen to call you? You'll refer them to someone else? Okay.
I don't offer that service.
Okay.
I think that's indicated on my price list itself. In many cases, we do not offer direct burials. Mr. Bozeman helped me with a lot of the legal. You may choose a direct burial, or you may choose something that doesn't require embalming, like a direct burial, blah blah blah. So I put all that in and then say, well, we do not offer direct burials, and so I'm very clear about what we do and will not offer.
Mr. Bozeman, has he met all the criteria for this location?
Yes, sir, as far as the laws are concerned, on the first one now, so.
Okay. We're doing this individually, one at a time now. Just
Okay.
remember that. Yeah, this is the tower.
This is the tower. Meets the requirements. Motion to approve the 5100 Poplar Avenue request.
Second?
Have a motion from Mr. Hinkle and a second from Ms. Taylor. Any further discussion? All in favor?
Aye.
Motion carries.
Mr. Chairman, I wish to vote no.
All right. So noted. Ms. Sal votes no. Congratulations on your new establishment.
Okay, then, the next one is Dusty Rose Mortuary LLC. It's located at 2319 Airport Interchange Avenue, Suite 5 in Memphis. This is a LLC. It's a different LLC. It's Dusty Rose Mortuary LLC, located in Germantown, Tennessee, with 2 members of this limited liability company. And likewise, as we did with the other one, these photos we'll pass to you to view. Who has the first group of photos? Okay, if Miss Johnson, if they can wind up with her, then we can get them back in their proper place.
Not offer or sell pre-need, is that correct?
That is correct.
It's a large space. What else do you plan on doing?
Actually, about a quarter of it will eventually be a preparation room, but I think your photos also show a garage door, so that's where I'm going to put my hearse, keep that, as well as a removal vehicle will stay in there. So there's plenty of room for embalming room, 2 vehicles, and a dressing and storage area. It is about 2,000 square feet.
These are all future things you're going to do.
Well, no, sir, I've actually leased that. We're going to go ahead and put the vehicles in there, and I'm going to dress bodies there. Everything but embalming, because I don't have the funds to put the prep room facility in just yet.
Where will the cremation be?
Cremations will outsource to Tennessee Cremations in Memphis.
Say you have a funeral, you lease that church, that's what you do really, isn't it?
Well, not lease, I'll pay them a fee, or make a donation to them every time we use it.
Okay, what I've often wondered, if somebody gets hurt, fall, break a hip or something, getting in and out of the church, is that gonna be your responsibility or the church's responsibility? I'm just from my
Dusty Rose Cremations and Memorial Services, the public face that I will be operating under and in the view of my customers and visitors, will be carrying a $1 million business insurance policy. That in conjunction with whatever the church has, we should cover that.
I'd wondered, I never did ask before.
I've often wondered what would happen when we were at their church and the same thing happened too. So.
Already set up in this area?
Yes, sir. Everything except the actual.
Operating now?
No, of course not.
No, I understand that, but,
For some reason, Mr. Hinkle, your microphone's not picking up there.
well, I'm sorry. So what you're doing here is just for the board to look at, or?
Well, no, I've actually ordered about $2,000 to $3,000 worth of equipment and supplies that I've gotten in there. I'm just waiting on you all to say it's okay. I'm not doing anything in there now, but I have gotten it prepared as best I can to dress and casket bodies, everything other than the actual embalming.
Does this have a ladies' room and a men's room?
It's got one unisex bathroom.
That's inside this unit that
It is inside.
you've
that.
got an individual bathroom and,
Yes.
and sewer and water and everything that's required.
Oh, yes.
The only thing that I see here that really jumps out at me, I want to explain something to you. I'm a retired building official, so I look for certificate of occupancies. You've got a problem with getting a certificate of occupancy according to this letter over some striping issues. Okay, have them been resolved?
I've got with me right now, I've got
Have you
with
got a
me-
certificate of occupancy for this building right now?
I don't have a certificate of occupancy yet. No, sir.
For any,
Asking for,
You've got equipment
don't have
in
a certificate of occupancy. Override local zoning?
It's not a matter of not wanting to get it or being able to get it. It was a matter of spending yet another sum of money to get something before I was able to use it. I've already signed leases with these places and with no guarantee that I'll be able to use them. I had to draw the line somewhere with when am I going to quit spending money until I know that I'm going to be able to operate. The only thing standing between me and a lease and occupancy permit is the restriping of that parking lot. I've got a letter here from an email from the owner of the building dated April 30th that says, "Please be advised, we have contracted to have the parking lot restriped. The job will be completed within 15 days." So that is that. That may be done already. I have not been down there. Again, in the interim, I would also point out the fact that we're not parking in that place anyway. I've got a garage door, and we're pulling our vehicles inside the location. We're not utilizing any outdoor parking whatsoever, but still, I have arranged to get it striped, and as soon as y'all tell me that I can have a license, I will go get the use and occupancy permit as well.
If you didn't get a use and occupancy and then we gave you, then we're allowing you to have a mortuary without a location theoretically that has not been approved by the local zoning. So I don't know. I think, you know, it's kind of like the horse before the cart here, or no horse maybe in a cart. So.
Well, for whatever it's worth, I have also got a picture here of the parking lot of the Memphis and Shelby County Board of Code Enforcement. There's not a stripe on their parking lot. The people who are saying I have to have stripes, I'm willing to have the stripes put on. You know, the whole thing when he included that, the use and occupancy permit was not per se something that the board said was required that I present. So that's why I did not spend a lot of time and effort doing that. This only came up with his zoning letter. He raised the issue, and I've addressed the issue, and I'm getting it taken care of. I would hate to lose another month for this when I can pledge that it's being taken care of. And again, frankly, it's a moot point because we won't be parking there anyway, nor will we have any visitors. It will be myself, my partner, and the deceased are the only people that are going there, and we're going inside through a garage door.
My question today is, if you do not have a certificate of occupancy to utilize that building?
No, sir. I do
Okay.
not have one right today, no.
I do have a question. Going back to the parking issue, here on page 2, where it says, minimum parking ratios provides that one parking space is required to be provided for every 10 seats within a funeral home. But this is not a funeral home. So then, are we saying that the whole parking lot has to be?
If we give them a license,
Right.
it's gonna be a funeral home.
If we give them a license, it'll be
It will be a funeral home.
which you're saying, I guess that's why I'm confused, because I didn't think it was going to be a funeral home.
Well, in the traditional sense, but in order to provide you all with a zoning letter, that's what the wording that they have to use is what's required of a funeral home. But what I'm doing is not in the traditional sense a funeral home. I don't have a chapel. It's not one location that families go to. It's an alternative, and it's a lower priced alternative. And I think it's going to be attractive from a marketing standpoint. But I'm having to work within the confines of the law that you require that there's a zoning letter. The zoning letter says for this to be called a funeral establishment, it has to have so many of these parking spaces. That's what I'm trying to accomplish, even though it's really not important. It's really not important because parking will not be an issue at this place. That's why I included with the letter from the church how many parking lots they have, or parking spaces, and their occupancy of their sanctuaries, because that's my only public assembly space, is at the church or my family's church. Nobody but a group of perhaps 4 people will come to Dusty Rose cremations and memorial services in Clark Tower, which is the family where I'll meet, and nobody at all will come to this other location other than myself, the removal partner, and the deceased. And then again, as I said, on those rare occasions when somebody wants to view an unembalmed remains before cremation out of necessity, I will have to take them down there as well. But there will be no no parking issues related to that location or property.
So if they wanted to view, they would not be viewing at this Tennessee Cremations. They'll be
No, sir.
viewing at this location here then.
Right, yes, sir. Again, I can't stress enough that I'm not offering that service. I'm going out of my way not to provide that service.
Till you obtain a certificate of occupancy, you can't use that building for anything. Why I keep asking about this certificate of occupancy, and you've got pictures showing all this stuff set up in there and all these improvements you've made to it. Do you own the building?
No, I'm leasing it.
You're leasing it?
A portion of it. I have an actual plat of the building.
I don't need a plat of it, because my problem is you're applying for established license for a piece of property that you don't have a certificate of occupancy. I'm gonna recommend that this be denied today until you come back with a certificate of occupancy, because I don't think this board should be issuing certificate license for buildings that the renter, owner, or occupant does not have a certificate of occupancy to operate that as the business you're wanting to operate in.
With your business model, wouldn't you be just as well off to contract, like the funeral home's going to do your embalming, just to pick up the bodies? And
No, sir, because as a prep room manager for Forest Hill, I received that job because of my abilities in body preparation and in appearances. When I worked in advertising, I had 20 years working doing ads for Maybelline. I'm one of the best body production people in town. The only reason I'm not doing it right now is the $40,000 that it costs to build out the prep room. I wish that I could. So in the long term, no. And also there are issues with Millington Funeral Home and other funeral homes. They don't have the space for me to come and dress and cosmetize and casket bodies out there. I just need to get the embalming done somewhere, then I'm going to bring them to this place. And then I'll do the cosmetic work, dress them, casket them, everything else. And as soon as I can get a prep room, an embalming room built out in there, which I hope will start within 6 months, it will happen. Obviously, I would rather go embalm a body myself in an hour than pay somebody $250 to do it. So that is not a long-term goal, is to keep farming that out. I want to do it myself.
do you know for a fact you can put a prep room in this building?
Absolutely, absolutely. In fact, legally, yes, absolutely. Physically, also, yes, very good. All the plumbing is already pretty much in place. It used to be a catering office, so we've got the
Backflow protectors. All
backflow.
that.
Yes, ma'am. Backflow protectors, hot and cold running water, mop sinks, everything. It's just a matter of putting up two walls, a door, an air-conditioned system, which is going to come as soon as I possibly can do it.
Just a question. If he gets the certificate of occupancy, is there any way that he could submit that to our executive director and then his license is granted without him having to come back before the board?
I personally would like to thank you for asking that question, ma'am.
I would have to look into that. I'm not sure right now.
I think the board had made a ruling or voted at some time since I've been here that all establishments of this sort would come before the board and would not give Robert. That's the reason it's here now. So unless things were changed, I don't know that we could vote on that to give that authority.
There may be some other moving items to think of too. I mean, Mr. Hanson has pointed out that there's not an air conditioner there, so if you're gonna bring deceased human remains into the building, and it coming up on June and July, what kind of problems is that going to pose? It's an open, as I understand it, it's an open space, so, and I know the plan is for no one to be there, but should someone enter the building, then whatever's inside that building is totally exposed to their eyesight. It's also the name of the proposed name of the applicant is Dusty Rose Mortuary LLC, which would indicate it's a mortuary service. So if there's not an embalming room there, then is that under Rule 0660-11-.06? I don't know, I'm just asking the question or bringing up does that have anything to do with engaging in any other act, omission, or practice that is misleading or deceptive? Maybe not, I don't know.
Is there any plan to provide some kind of privacy for the preparation area?
Yes, ma'am, in the long term, yes, the room is about 2,000 square feet. Approximately a quarter of it is planned to be walled off, which will be, and then tiled, air conditioning system put in, all of that. So yes, totally.
What would you do in the meantime for some privacy?
Shut the garage doors. Shut the garage doors. There's nobody else in there. There's no windows. There's no visibility. We'll bring the bodies in through the garage door and shut the door behind us.
And there's no ventilation, evidently, if there's no air conditioning either right now, so.
No, there is not. There is not. Now, we are looking at putting in a refrigeration unit, and all bodies will come already embalmed to the facility. There will be no unembalmed bodies brought to the facility.
Cremated, they wouldn't be embalmed, though.
Yes, sir, I'm offering full service cremations. That's what I'm doing. So all my bodies are going to be embalmed.
Prior to cremation.
I wanted cremation, but I wanted just to see me one more time there.
That's the product. That's the service that I'm putting on the price list that I don't want to sell. There are
Possibly do that, though.
could possibly, if somebody
That's
wants
right.
to pay me $1,000 when people are fighting for $800 over it down the street. I don't want to offer direct cremations. I want to embalm the bodies and give families closure and a 2-hour period of visitation and a funeral service, and then cremate the body afterward. So, and I plan to be very forthright with these families that I don't want to. I told Mr. Bozeman I really didn't even want the direct cremation on my price list. I don't want to offer that service.
Yes, from my understanding, from what all has been discussed now, and especially with what Mr. Gribble says, it sounds like that you probably need to go back and go ahead and put all these things in order before you're granted the license, so that you're not in violation and we're not in trouble either. Now, that's kind of my understanding. Because if we grant a license for the establishment license as a mortuary, these things have to be in place. The air conditioning and whatever else, so that you are in compliance. Am I understanding correctly?
Yes.
Patterson, we can't hear you. If you'll move up closer, please.
I can't see that we should even consider licensing that building like it is right now, because we wouldn't license a funeral home if they didn't have a facility to take care of the business, and yours is not.
Sir, I'm aware of several funeral homes in Memphis who have no such embalming facility.
I'm not saying just the embalming, but you know, that building is not ready for occupancy.
Not for an establishment license, it's not.
I'll get it on the floor. Mr. Chairman, I move to deny the application.
Second motion to deny.
I have a moval to deny from Ms. Sal, a second from Mr. Hinkle. Any further discussion? All in favor?
Aye.
Motion carries. So on the matter of the funeral home, it's denied as is. All right. Thank you, sir. All right. Next order is military rules from Ms. Richardson, her Assistant General Counsel.
Public Chapter number 122 of the Public Acts of 2013 requires all regulatory boards to adopt rules to expedite the issuance of a license or registration to military applicants and applicants with spouses in the military. I provided you all with a draft of those rules on the iPad for your review, so please take a moment to look them over. And if you'd like an opportunity, or if you would like to propose any changes, now is the time to do that.
I ask a question? In essence, what does this do?
Well, first of all, it talks about temporary permit. That should actually be temporary license.
Wait, you go back.
Sorry?
I can't listen as fast as you talk.
First of all, it discusses a temporary permit. That should actually be a temporary license. So with your permission, I would change that terminology to make it more consistent. But in essence, the public chapter number 122 requires that we do an expedited license process. We have an expedited license process for applicants that meet the requirements, which would be military applicants and spouses of individuals in the military. And so this would just require, if the board,
I need a for instance. I need an example of what you're talking about.
For instance, if someone is transferred here that's a member of the military and they're licensed in another state, this would allow them to get a temporary license in Tennessee once they show that they've met, if the board's deemed that the license process in the other state is sufficiently similar to our requirements. It would just give them
Rather than
expedited.
reciprocating just to get a term.
Right. It would just
temporary
be
license.
temporary to get them so they could practice sooner because of the move. And then that temporary license would become permanent once they meet all the requirements. That's my understanding.
If the board will recall, back in November or December 1, I, off the top of my head, don't remember which month it was, but it was one of those 2 months, I think. At that time, Assistant General Counsel was Benton McDonough, and he presented this to the board. And the board determined at that time, well, first of all, at that time it was believed it was optional as to whether or not the board did this. But since that time, it's not, we've come to the understanding it's not optional. So at that time, the board elected to not adopt the military rules. But we have been informed that it's a requirement that the as Ms. Richardson has said, the Chapter 122 of the Public Acts of 2013 says the board shall. So it shall adopt it, but the board will still have, it's my understanding, very have a lot of leeway as to whether or not these are approved on an individual basis. Because you adopt the rules doesn't mean that everyone that shows up before you must be approved. If you read through this, it talks about in the opinion of the board, and the board may do some things. So it's...
It concerns me a little bit to give somebody a license and then say that you can give them a temporary license, but then they'll get their regular license once they fulfill all the requirements for that license when we do
Without
not.
having to pay any fee.
Yeah.
Well, they would still be subject to the standard renewal requirements, and once the renewal period comes up, it's my understanding that then it would become, once they meet those requirements, it would become a license like all the others.
Unless I'm reading it wrong, it almost sounds like, though, that we would be giving somebody a license even though they haven't finished their educational requirements, and then when they do, they'll get their permanent license. But we've given them a license till they get that done, where we don't do that to other people. We require them to finish their educational. Maybe I'm looking at it wrong. I don't know.
If they're in the military, how are they going to be able to practice as a funeral director or and/or embalm?
This is after,
This is like,
toward the end there, Ms. Sell, it talks about, this is after they're discharged. It was my understanding, because it says that the certificate of restoration or permit shall be eligible for renewal pursuant to this subsection for 6 months from the person's release from active duty. Well, that's talking about if they fail to do their continuing education, then they would have 6 months after the release of active duty to fulfill that.
Why do they need a temporary license to do that? They'd have to be licensed in order to be required to have continuing education in the first place.
But this also applies if they already had a license and then they were inducted into the military. then, and put on active duty, then they would have this extra 6 months toward the end.
Right.
to-
Number 3, which is what Mr. Gerbold was talking about, is if the individual is in the National Guard or Reserve, or he was called away, and because of that, he didn't meet his continuing education requirements. That section of the rule would say that he would be allowed to continue to have his
6
license when he
months.
returns, as
And-
long as he completes it within 6
That's
months.
fine.
Yeah, I
That
can see that,
understand.
yeah.
Okay.
And it can be from another state.
Sorry?
You have to,
Can be from another state. Did I hear you say that, if he was employed at another state and then he goes to service and he,
Right, and then if he transfers here, that would, or not transfers, he moves here after the service, this rule would apply as
Okay.
well.
our law requires that the person to have graduated from a school approved by the American Board of Funeral Service Education. This says that you may substitute some military training. It doesn't say you're required to, so you could still, the rule doesn't trump what the law says. The law is still your guiding factor. It just gives you some leeway if you decided that someone had military experience that could be substituted. It gives you that authority, but not, it's permissive, it's not required.
Right, and like he said, number 2, it says at the bottom that a board still would make the determination that that education and training the individual received in the military would be equivalent to the training they would receive otherwise in our rules and law.
As far as fees, Ms. Sal, it was my understanding that they would have to pay the fee that if they were gonna apply for this, then they would still have to pay an application fee just like any other fee. Because up there at the top, it talks about upon application and payment of all fees.
Right, this rule does not change any fee requirements.
make a motion, we
Oh,
accept that.
excuse, I misread that. I thought it was waiving the,
Second.
or the penalty rather, excuse me.
Have a motion from Mr. Patterson, a second from Mr. Neal. Any further discussion? All in favor? Motion carries.
So everywhere it's temporary permit, you're gonna get that changed then.
I'm a retired National Guard member. I served nearly 32 years. The last 25 years, I was a tank commander, so I want a temporary bomber and bomber's license and a temporary funeral director's license.
We can work it out.
Board still has to determine that their eligibility requirements are still met. So- But yes,
We'll take
the
that under
permit word
advisement.
will be changed to license.
Yeah, that's the problem I have with this. It doesn't, this education thing pertaining to the industry, there's nothing in my military training that had anything to do with funeral home running. Shut up, Wayne.
Okay. Our next,
Wait, I'm not finished.
okay, sorry.
Sorry. It's my recommendation that these rules be considered for promulgation as proposed rules. And this is different. In lieu of holding a rulemaking hearing, we'll be proceeding under Tennessee Code Annotated Section 4-5-202A2. This states that an agency may post the proposed rules to the Secretary of State's webpage, and they will become promulgated 60 days after the first of the month following their posting without holding a hearing, unless 25 persons affected by the rule, in association with at least that many members, a municipality, or a majority of any standing committee of the General Assembly requests a hearing. They will then be effective 90 days after that 60-day period expires. And I recommend to do that instead of the traditional rulemaking hearing, mostly because Public Chapter 122 mandates that we do this, so I don't really understand. Well, I doubt that there will be many people opposing the rule. But if there are enough people opposing the rule, we will do the rulemaking hearing. But prior to initiating the rulemaking process, the agency is required to conduct a review of whether a proposed rule affects small businesses. And then in my review of the proposed rule, I have proposed the following answer to these questions, which you may adopt or alter. And this is the regulatory flexibility analysis, economic impact statements that the board needs to adopt with any rule. And so these questions for small businesses are as follows. Number 1, the extent to which the rule may overlap, duplicate, or conflict with other federal, state, and local governmental rules. And my proposed answer would be there will be no overlap, duplication, or conflict with other federal, state, or local governmental rules. And number 2, clarity, conciseness, and lack of ambiguity in the rule. And my proposed answer would be the rules are clear in purpose and intended execution. The implementation of the proposed rule will not increase any ambiguity in the rules as a whole. Number 3, the establishment of flexible compliance and reporting requirements for small businesses. My proposed response is these rules do not create any new compliance or reporting requirements. Number 4, the establishment of friendly schedules or deadlines for compliance and reporting requirements for small businesses. And the proposed military applicant rule will expedite the licensure process for certain military personnel and in some cases for the spouses of military personnel. And number 5, the consolidation or simplification of compliance or reporting requirements for small businesses. And there are no new compliance and reporting requirements as a result of this amendment. Number 6, the establishment of performance standards for small businesses as opposed to design or operational standards required in the proposed rule. And my response, these rules do not set out operational or design standards. As such, there are no performance standards for small businesses as a result of this amendment. And number 7, the unnecessary creation of entry barriers or other effects that stifle entrepreneurial activity, curb innovation, or increase costs. It does not appear that these amendments will erect barriers or have other effects which would stifle entrepreneurial activity, curb innovation, or increase costs. That is my proposed response to the regulatory flexibility analysis. And so if you would like to accept that or change it, you would need to adopt the analysis yourself.
Motion to adopt.
Have a motion from Mr. Hinkle, a second from Mr. Patterson. Any further discussion? All in favor of adoption? Aye. Motion carries. The next is the adoption of establishment and...
I'm still not finished, sorry.
You're still not finished?
Yes, there are 2 more things regarding these rules that you need to adopt. And the next one would be an economic impact statement. And then that statement is made up of 6 questions pursuant to Tennessee Code Annotated Section 4-5-403. And those questions and my proposed answers, which you may adopt or alter, are as follows. And these are 6 questions. The first one is the type or types of small business and an identification and estimate of the number of small businesses subject to the proposed rule that would bear the cost of or directly benefit from the proposed rule. And my proposed answer is the proposed rule is a licensing requirement that will apply to all license and registration applicants equally if the individual meets the requirements. Therefore, businesses will not have any costs associated with this rule. Second question, the projected reporting, record keeping, and other administrative costs required for compliance with the proposed rule, including the type of professional skills necessary for preparation of the report or record. My proposed answer is there are no projected reporting, record keeping, or administrative costs for small businesses associated with this rule. Number 3, a statement of the probable effect on impacted small businesses and consumers. And this rule has no projected impact on small businesses or consumers. Number 4, a description of any less burdensome, less intrusive, or less costly alternative methods of achieving the purpose and objectives of the proposed rule that may exist and to what extent the alternative means might be less burdensome to small businesses. And this rule will ease the burden of applying for a license or registration for those applicants who meet the requirements. There are no less burdensome, intrusive, or costly methods to achieve the purpose of the rule. Number 5, a comparison of the proposed rule with any federal or state counterparts. And there are no federal counterparts to this rule. Public Chapter 122 requires all regulatory boards to adopt rules expediting licenses for military applicants and applicants with spouses in the military. The boards are adopting rules substantially similar to this proposed rule. And number 6, analysis of the effect of the possible exemption of small businesses from all or any part of the requirements contained in the proposed rule. And my proposed answer would be that this rule does not require small businesses to change their operations. Therefore, there is no need for an exemption. And that's my proposed answer to the economic impact statement. So you can either alter it or adopt it.
Adopt.
Second.
Have a motion from Mr. Hinkle, a second from Mr. Neal. Any further discussion? All those in favor? Aye. Next.
Pursuant to Tennessee Code Annotated 4-5-228, the agency is also required to adopt a simple declarative sentence on whether the rule or regulation may have projected financial impact on local governments. And my proposed answer is that there's no proposed financial impact on local governments.
Okay.
Have a motion from Mr. Hinkle, a second from Ms. Sow. Any further discussion? All those in favor?
Aye.
All right, now the board may adopt the rules to be filed for promulgation as proposed rules, but this vote needs to be by roll call.
All right, if you will call the roll, Ms. Johnson.
Wayne Hinkle,
Yes.
David Neal,
Yes.
W.T. Patterson,
Yes.
Jane Grey Sal,
Yes.
Robert Starkey,
Yes.
Anita Taylor.
Yes. Yes.
I have 6 yeses.
Okay, we have 6 yeses.
And finally, I would ask that the board consider a motion to allow me to proceed with these rules pursuant to a notice of rulemaking hearing should the required request for a hearing be received.
So moved.
Second.
Have a motion from Ms. Sow, second from Ms. Taylor. Any further discussion? All those in favor?
Aye.
Aye.
Motion carries.
I'm finished. That's it.
Now, Ms. Richardson, if you will have the adoption of establishment inspection forms.
All right. Public Chapter 690 gives the board authority to conduct inspections of funeral establishments. The scope of the inspection is limited to an inspection checklist that shall be published on the board's website and any other plainly visible violations. The board needs to adopt the inspection checklists. There are 2, one for funeral establishments and one for crematories. Please review the establishment inspection report on your iPads.
These are the same inspection forms that have been used for the past few years. Just the revisions have just been to make it nicer, to make it more presentable. But as far as there are no substantive changes to it. It's
Inspectors like the new inspection forms.
Yes, sir. Hadn't seen it yet, but I'm sure we will.
Motion to accept.
Have a motion from Mr. Hinkle, a second from Mr. Patterson. Any further discussion? All those in favor?
Aye.
Any opposed?
Mr. Hinkle, Mr. Mosman was very instrumental in developing the forms to begin with.
I thought he was.
All right. Do we have any new business to come before the board?
Both of them? Establishment and the cremation form?
Yes, sir, that's what,
Right, I was unsure whether, did that motion just accept one or both?
I'm
of them?
going,
I
I
thought
made
it
a
was to
motion,
do
I'm going to
both,
make a
but-
motion to accept the cremation inspection form also.
All right. Have a motion from Mr. Hinkle, a second from Mr. Patterson. Any further discussion? All those in favor? Aye. Okay, that's on the cremation form. The first one was the funeral home form, okay? Any new business to come before the board? I'll accept a motion to adjourn.
Motion we adjourn?
Make a motion for Mr. Neal,
Second.
second from Ms. Taylor. All those in favor? Meeting is adjourned.